Jay Hirsch has just come from a hearing in General Sessions Court in Lawrenceburg, Tennessee. Jay Hirsch has challenged subject matter jurisdiction and is challenging subject matter jurisdiction. Jay, at the hearing this morning, you were before Judge Mike Harris. What did he say, and what was he insisting on, and where was he wrong?
When I went into the court, I told him I was there in special appearance only for the limited purpose of challenging the court's subject matter jurisdiction. And that was based on two affirmative defenses, which were detailed in the motion that I had filed, and also the request for mandatory judicial notice of facts and law. The two defenses were, number one, the administrative remedy for hearing contested cases concerning licenses had not been exhausted. And the case law is clear that until there's an exhaustion of all administrative remedies, which would come out of the Department of Safety in Nashville, the courts do not have jurisdiction. They cannot do review. The second was that the citation was void on its face. There were numerous statutory requirements of information that had to appear, such as the court's location, the date, and the time for a hearing is to be put on the citation, affixed, if you will, by the issuing officer. It was left blank on the citation that was issued to me. That makes it void. Next, there were numerous instances where information was falsified. The citation had a place for an affidavit or a sworn statement that everything was true and complete. Well, the officer had affirmed that he had appeared before a magistrate, and he had not. I have a visual proof. I took a picture with my phone on his clipboard with the original citation. And furthermore, the magistrate lied, said he appeared. It's void on its face.
Let me just ask, to get past the fatal defects in the citing instrument, how is the problem of subject matter jurisdiction properly, how is that challenge properly made? You cite lethal defects in the charging instrument, and then also the administrative remedies failure to exhaust problem. Why do these deprive the court of subject matter jurisdiction? And what should have happened when you mentioned this challenge in that courtroom when you had the DA man sitting on the right there, Brent Cooper's associate attorney?
Case law shows clearly that a challenge to subject matter jurisdiction has to be addressed immediately by the prosecutor. Whoever it is that is invoking the court's jurisdiction, not the judge, but in most cases, the DA. The DA is supposed to then stand and establish on the record that the court does indeed have jurisdiction. And my two affirmative defenses basically would eliminate any meaningful argument by the DA. But today's case, the DA sat there. Judge Harris would not even acknowledge that I was challenging the jurisdiction. He said the case today is only for an arraignment. And he said, we'll set up a date to hear your motions later. Well, that's wrong.
Jay Hirsch, how can a judge whom you are showing doesn't have subject matter jurisdiction set another hearing and compel you to be there when the underlying authority that he has is being challenged squarely by you? How can he do that?
It's illegal. It's unlawful. It has no precedent anywhere. So that when you challenge jurisdiction, everything in the whole proceedings has to stop. The brakes are put on. Nothing happens after that point. So the judge scheduling another hearing and refusing to acknowledge my challenge is wrong.